The laws of divorce in Islam are detailed and designed to provide a structured process for the dissolution of marriage, while encouraging reconciliation. The distinction between the procedures for men and women stems from the specific rights and responsibilities assigned to each within the traditional Islamic marriage contract. Here is a comprehensive breakdown of the laws of divorce and the rationale behind the gender-based distinctions. A. The core philosophy of marriage and divorce in Islam. In Islam, marriage is a sacred contract, AQD, not a sacrament. While it is a solemn covenant to be respected, it is also a legal agreement that can be dissolved under specific conditions. The guiding principles for divorce are permissibility but dislike. Divorce is considered the most disliked of permissible things, halal, in the sight of God. The Prophet Muhammad said, "Of all the permitted things, divorce is the most hateful in the sight of Allah. Last resort, it should only be resorted to when all efforts of reconciliation have failed." Structured process. The process is designed to prevent hasty decisions, allowing for a cooling-off period and multiple opportunities for reconciliation. Types of divorce and procedures. The primary forms of divorce can be categorized based on who initiates it. 1. Divorce initiated by the husband, talaq. This is the most common form of divorce. The husband pronounces the divorce by saying, "I divorce you," or words to that effect. This process is not instantaneous. It involves stages. The revocable divorce, talaq al-raji, first and amp, second declaration. A husband can pronounce divorce twice. After each pronouncement, there is a mandatory waiting period, iddah, or 3 menstrual cycles, or 3 months if the woman does not menstruate. Purpose of iddah. This serves multiple purposes. A. To ascertain if the wife is pregnant, establishing paternity. B. To provide a cool-down period during which reconciliation is actively encouraged. During the iddah, the husband has the right to rescind the divorce and resume the marriage at any point, without needing a new contract. The couple can and should continue living together. The final, irrevocable divorce, talaq al-ba'in. Third declaration. If the husband pronounces divorce for the third time, or if the waiting period after the first or second divorce passes without reconciliation, the divorce becomes final and irrevocable, ba'in. Consequence: the marriage is immediately dissolved. The couple cannot remarry unless the wife first marries another man of her own free will, consummates that marriage, and then it ends through divorce or death. This condition, known as ta'lil, is designed to seriously discourage the frivolous use of the triple divorce. Innovated divorce, talaq al-bid'ah. This is the controversial practice of pronouncing the triple divorce in one sitting, e.g., "I divorce you, I divorce you, I divorce you." While historically considered sinful but legally effective, many modern Muslim countries have banned this practice through legislation, requiring divorces to be registered and pronounced sequentially to allow for reconciliation. 2. Divorce initiated by the wife. A woman can seek a divorce through several mechanisms, which are more procedural than the husband's talaq. Stipulated in the contract, talaq al-tafwid, the husband can delegate, tafwid, his right of divorce to his wife in the marriage contract. She can then initiate a divorce without going to court, simply by pronouncing it as per the delegated authority. This is becoming increasingly common in modern marriage contracts. Judicial divorce, cul. If the wife has a strong aversion to continuing the marriage, e.g., due to incompatibility, lack of provision, or abuse, but the husband refuses to grant a talaq, she can seek cul. Process. She petitions an Islamic judge to annul the marriage. Financial sacrifice. In a khul, divorce, the wife typically returns the dower, mahr, she received at the time of marriage or gives some other financial compensation to the husband. This is based on the precedent of a woman who came to the Prophet Muhammad asking for a divorce from her husband. The Prophet asked her to return the garden her husband had given her as a dower. Grounds: classical law requires the husband's consent for khul, but modern interpretations and family laws in many countries allow a judge to grant it based on valid grounds, harm, desertion, etc., even without the husband's consent. Judicial annulment, fasq. A wife can seek a court-ordered annulment of the marriage for specific, compelling reasons. Grounds for fasq include impotence of the husband, failure to provide financial maintenance, nafaqah, desertion or absence of the husband, cruelty or abuse, physical or emotional, a serious, incurable disease or insanity. In such cases, the wife is not required to return her dower. See why the distinction between males and females. The different procedures are not based on an idea of spiritual inequality but on the distinct legal and financial roles assigned to each party in the traditional marriage structure. The financial responsibility factor: the husband bears the sole and unconditional financial responsibility for the family, including providing the dower, mahr, and all maintenance, nafaqah, for his wife and children. The wife has no legal obligation to spend her own wealth on the household. Because the husband carries this continuous financial burden, classical jurists argued he was given a more direct exit clause, talaq. His decision to divorce has immediate and direct financial consequences for him, as he must pay the wife her full maintenance during her iddah and any deferred dower. Protecting the wife from impulsive divorce: the wife's financial security is a primary concern. The procedures for khul and fasq ensure that her rights are protected by a judicial process. She is not expected to bear the financial risk of an impulsive decision. The requirement for her to often go through a court, khul, fasq, or to have delegated authority, tafwid, acts as a check against frivolous divorce initiated by her, which could otherwise be used as a tool of financial pressure on the husband. Emotional and biological considerations: the iddah waiting period is primarily for the wife, to determine paternity. This biological reality necessitates a different procedural step for her. The classical perspective held that men might be more likely to act in a moment of anger, hence the multi-stage talaq process is designed to curb that impulse. A woman's desire for divorce, in this view, was seen as more likely to be a considered, long-term decision born out of genuine distress, hence requiring a formal petition. Conclusion: a modern perspective. While the classical laws reflect a 7th century societal structure, the underlying principles are justice and the prevention of harm. In modern times, there is a strong movement among scholars and reformers to re-emphasize the ethical spirit of the law, which heavily discourages arbitrary divorce and promotes reconciliation. Many Muslim-majority countries have enacted family law codes that regulate and often equalize the process, for instance, by requiring all divorces to go through a court and by expanding the grounds on which a woman can obtain a judicial divorce, fasq, without financial penalty. The key takeaway is that Islam provides multiple avenues for both spouses to exit an unsuccessful marriage. The distinction in procedure is rooted in a specific socio-economic model designed to protect the financial rights of the wife, who, in that historical context, was the more vulnerable party in the event of a divorce.